of the Rio Declaration. And this obligation goes along and is blended in together with the obligation to carry out a thorough environmental impact assessment. Your Excellencies, when we look at the compromise, we are told under paragraph 10, Your Excellencies, that there was no thorough environmental impact assessment in the last sentence of the said paragraph. And Your Excellencies, as we know, the respondents will argue that there is no direct link between the death of the 9 hawksbill turtles and the oil spill that occurred. However, Your Excellencies, is it a coincidence that 22 days after an oil spill that was catastrophic, 9 hawksbill turtles died? Your Excellencies, I leave that question to you because it is for you to deduce whether it is a coincidence or not. However, we would also argue that this presents some level of scientific uncertainty, and therefore it places a greater obligation on the respondent state to carry out a thorough environmental impact assessment, as was stated in the pulp mills case on the River Uruguay, in which the court established that an environmental impact assessment is particularly mandatory where activities of a state are likely to cause transboundary harm and, for that matter, in a shared resource. Your Excellencies, as my co-counsel stated in the beginning, the state of Sarkovia entirely depends on this resource for their economic well-being. And so what we have at stake is the economy of an entire nation and its future generation. And so we call upon this court to find that any activities under the unitization agreement should be suspended for lack of carrying out a thorough environmental impact assessment in order to establish with certainty any possible effects it may have on the environment. With that, Your Excellencies, and if you have no questions, I will proceed to address the question on compensation. Thank you, Your Excellencies. Thank you. So, on matters of compensation, we do argue that the polluter pay principle is very clear, that a state must take responsibility for any damages that they cause to another state. Your Excellencies, I would like to draw your attention to the Chozo factory case between Germany and Poland. Your Excellencies, this was a case before the Permanent Court of International Justice. In this case, Germany gave up or surrendered some of its rights to certain properties to the state of Poland on condition that the state of Poland will not in any way violate or give these rights to any or forfeit these rights to any other person. But subsequently, they did so. And Germany incurred several losses. And Your Excellencies, they approached the court for reparation, and this was granted. In the same way, Your Excellencies, the court found that since the actions of Poland directly contributed to major losses to the state of Germany, they were responsible for making adequate reparations. Your Excellencies, the question that we are then to ask ourselves is where and who were responsible for these actions. In the Trail Smelter case, the arbitral tribunal established that it is the responsibility of a state to make sure that any activities of individuals within their jurisdiction do not in any way affect another state. Your Excellencies, in the same way, it was the responsibility of Himalaya to ensure that the activities of the company in question did not affect other states as well. And as we read from the fact sheet, Your Honor, Your Excellencies, we do find that this company went ahead to drill an oil well when they knew very well that they did not have the required experience and expertise to carry out these duties. And so it shows a great level of negligence and lack of responsibility on their part. And therefore, they do not have any other option but to make reparations and compensations for the damages caused. And so, Your Excellencies, unless you have any questions, I will invite them.
Okay. A quick one. Do you have any case law to back up what you're arguing for? So, for instance, is there any case law existing already showing the unitization agreement between two countries? And something similar to what you're arguing for right now, that we have jurisdiction without involving Abotia. Do you have anything to that effect to share with us?
You have jurisdiction?
Yes.
Yes, Your Excellencies, we have the Lockerbie case.
Okay.
This was between Libya and the UK, in which they had an agreement under the Montreal Convention. And in this case, there was a requirement under Article 14 of the Montreal Convention that in the event that there were negotiations and mediation but they failed, then they would submit to the court's jurisdiction to resolve the dispute. In the same way, Your Excellencies, in our case, under Article 27.3 of the CBD, which is majorly the convention governing the issue in question, it is a provision that in the event that parties negotiate and they fail to resolve the dispute, then they resort to the International Court of Justice.
But did the Republic of Nabotia agree to this?
Your Excellencies, they are party to the Convention on Biological Diversity, but the aspect of consent on their part is not present. And parties, there is a precondition that they have to give consent to be enjoined.
Exactly.
Your Excellencies, so as I conclude our prayers before this court, my time is over, Your Excellencies. I ask for 1 minute to conclude on my prayers.
Yes, please conclude.
Most obliged, thank you. So we do humbly implore this court to find that it has jurisdiction to hear and determine the matter in question. Secondly, that the respondent state did not exercise due diligence in carrying out their obligations, and that the unitization agreement in question is invalid and its activities should be suspended. And finally, that the respondent state should make compensation to the applicant state. With that, we rest our case, Your Excellencies.
Thank you very much indeed.
Thank you.
Let's have the response, please.
Mr. President, Your Excellency, once again, my name is Chitindi Marvelous. With the 30 minutes that we've been given, I will, in the next 10 minutes, respond to the applicant's submission in regards to issue 1, and my co-agent shall use the next 20 minutes in responding to issue 2 and issue 3 as raised by the applicant. Your Excellency, subject to the convenience of this Honorable Court, I'd like to proceed. Your Excellency, the respondent are not contesting the jurisdiction of this Honorable Court in regards to the state of Sokovia and Himia. However, the preliminary objection that we raised before this Honorable Court is that this Honorable Court shall not have the jurisdiction if the state of Nabotia is not enjoined to this matter, based on the unitization agreement that we have with the state of Nabotia. And Your Excellency, to clarify, agent of the applicant had submitted before this Honorable Court that the state of Nabotia has not consented to the jurisdiction of this Honorable Court. However, Your Excellency, I would like to draw the attention of this Honorable Court to paragraph 6 of the facts, which clearly shows that the state of Nabotia has consented to the jurisdiction of this Honorable Court in regards to the Convention on Biodiversity, pursuant to Article 27. With this, Your Excellency, would like to draw a roadmap on how the respondent shall argue before this Honorable Court in responding to the applicant's submission. Your Excellency, on the first hit, the respondent shall submit before this Honorable Court, or rather shall give reasons as to why the state of Nabotia should be joined to this matter. And secondly, Your Excellency, that the unitization agreement is valid and therefore the state of Nabotia should be joined to this matter. If I may proceed to the first head, Your Excellency, indeed, this Honorable Court has the jurisdiction to handle this matter pursuant to Article 36 of the International Court of Justice, which gives this Honorable Court jurisdiction to handle contentious cases and give advisory opinion. Your Excellency, for a state to be parties to a contentious case, such as this one, in persuading this Honorable Court, the respondent would like to rely on the Handbook on Accepting the Jurisdiction of this Honorable Court, Model Clause of 2014 at page 34, which is to the effect that for a state to be parties to a contentious case, it must have access and it must have consented to the jurisdiction of this Honorable Court. Your Excellency, this drives me to the first criteria in regards to access. Your Excellency, it is the respondent's humble submission that Article 35 of the International Court of Justice statute provides that all members that are parties to the International Court of Justice have access to this Honorable Court. And furthermore, Your Excellency, Article 93 of the United Nations Charter of 1945 is also to the effect that all members of the United Nations are ipso facto parties to the International Court of Justice. And Your Excellency, driving this Honorable Court's attention to paragraph 4 of the facts, it is clear that the state of Himia, Sokovia, and Nabotia are members of the United Nations. And therefore, Your Excellency, it is the respondent's humble submission that the state of Himia, Sokovia, and Nabotia have access to this Honorable Court. This drives me to the second criteria in regards to consent. Your Excellency, it is the respondent's argument that the jurisdiction of this Honorable Court is based on the consent of the state to which it is open. As we have established that indeed the three states have access to this Honorable Court. Article 36, Clause 2 of the International Court of Justice statute provides for ways in which a state may consent to the jurisdiction of this Honorable Court. And Your Excellency, it is through a unilateral declaration, and secondly, through treaties or convention, thirdly, through special agreements or forum prorogatum. And Your Excellency, as seen under paragraph 4 of the facts, it is clear that the state of Himia and Sokovia have unconditionally accepted the jurisdiction of this Honorable Court, and of which we are aware that indeed the state of Nabotia has not consented to the jurisdiction of this Honorable Court as compulsory. However, Your Excellency, as I earlier stated, a state may express its consent through a convention or a treaty. And as seen, relying on paragraph 6 of the facts, it is clear, Your Excellency, that the state of Nabotia has consented to the jurisdiction of this Honorable Court in regards to Article 27 of the Convention on Biodiversity on the interpretation and application of that convention. And Your Excellency, with this, we pray to this Honorable Court, indeed, to find that the state of Nabotia has access and has consented to the jurisdiction of this Honorable Court. Furthermore, Your Excellency, as seen under paragraph 8 of the facts, indeed, it is clear that the state of Nabotia has made a revocation notice in regards to the United Nations Convention on Law of the Sea. We are not disputing the revocation. Indeed, pursuant to Article 287, the revocation is valid as three months has elapsed. And indeed, the acts before this Honorable Court happened in 2014. And the revocation notice, as seen under paragraph 8, was made on 1st June 2015. And the matter before this Honorable Court was brought by the applicant state on 4th June 2016. And indeed, 3 months has elapsed and the revocation notice is valid. However, Your Excellency, relying on the case of Rodo versus Trinidad, before the Inter-American Court on Human and People's Rights, indeed, this case is persuasive to this Honorable Court. However, we pray that this Honorable Court borrows the decision that was made in regards to the denunciation that was made by Rodo by Trinidad. Your Excellency, the court noted that the denunciation by the state of Trinidad did not in any way affect the jurisdiction of the court for the acts that had happened prior to the denunciation. And Your Excellency, in the instant facts, it is clear that the state of Nabotia made a revocation notice after the acts had already happened. And with this, Your Excellency, we humbly pray to this honorable court that it should find that indeed it has the jurisdiction to, and it has the powers to enjoin the state of Sokovia, and this court should withdraw jurisdiction if the state of Nabotia is not joined to this matter. Your Excellency, this drives me to the second head of argument in regards to the unitization agreement. Your Excellency, according to Jacqueline Weaver and the journal, pardon Your Excellency, according to Jacqueline Weaver in an article, pardon Your Excellency, according to Jacqueline Weaver in an article in the Austin Journal of International Law, Volume 28, Your Excellency, she defined a unitization agreement as a joint coordinated operation of oil or gas reservoir by all the owners of the rights in the separate tract overlying the reservoir. And Your Excellency, as seen under paragraph 8, pardon Your Excellency, as seen under paragraph 10 of the facts, indeed it is clear that the state of Nabotia and Himia entered into a unitization agreement in regards to the oil reserve that was discovered in the shared continental shelf. And Your Excellency, furthermore, paragraph 15 of the facts, Your Excellency, it is clear as to the content of the unitization agreement. If I may read in verbatim. Your Excellency, paragraph 15, line 4, from the diplomatic note that was sent back in reply to the state of Sokovia's claim, line 4, it states that the unitization agreement duly qualifies that damage and liability shall be shared between the two contracting parties in the event of an oil spill or damage of transboundary nature. And Your Excellency, indeed, the matter that the applicant state have brought before this honorable court is in regards to the oil spill, and they claim that there is transboundary harm. And Your Excellency, as in the unitization agreement, in case of any oil spill or transboundary harm, the liability shall be shared between the states. And if this court goes ahead to make a decision that this honorable court has a jurisdiction if the state of Nabotia is not joined by the powers that it has under Article 59 of the International Court of Justice, which is to the effect that this honorable court is not bound by its decision, but the decision binds the parties to the matter. Your Excellency, how then should we go ahead and ask for the state of Nabotia to pay part of the compensation that the state of Sokovia is asking for? With this, Your Excellency, we pray indeed that it should find in favor of the respondent that this honorable court should withdraw jurisdiction until the state of Nabotia is joined to this matter. Unless there are any other questions, I'd like to cede the floor to my co-agent.
Please, you can pass it on. Thank you.
Much obliged, Your Excellency. Your Excellencies, for record purpose, my name is Swale Hemed Wengo. I'll be responding to the applicant submission regarding to the second and third issue respectively. Subject to the convenience of this honorable court, I'm ready to proceed. Your Excellencies, learned agent of the applicant made allegations before this honorable court without any proof. And it is important to note before this honorable court that as an officer of this honorable court, it is wrong and unethical for you to mislead the court. And Your Excellencies, with all due respect to learned agent of the applicant, he actually went ahead and misled this honorable court. First and foremost, Your Excellency, learned agent of the applicant argued that the respondent state has an obligation to conduct an environmental impact assessment pursuant to the provisions of the Convention on Biological Diversity 1992. And specifically, the provision that talks about environmental impact assessment under the 1992 Convention on Biological Diversity is Article 14 of that convention. And Your Excellencies, specifically Article 14 clearly states that states must, as far as appropriate and applicable, put procedures for conducting an environmental impact assessment when a plant activity is likely to cause adverse environmental effect on the biological diversity. A crucial point to note, Your Excellencies, in the provisions of Article 14 of the 1992 Convention on Biological Diversity is the word as far as appropriate or applicable. Your Excellency, this same position was reiterated in Article 206 of the 1982 United Nations Convention on the Law of the Sea. Specifically, it provides that states must, as far as practicable, assess the potential of an activity to cause effects to the marine environment when such activity is likely to cause substantial pollution or significant harmful changes to the marine environment. Now, Your Excellencies, Article 206 of the United Nations Convention on the Law of the Sea 1982 reiterates the word as far as practicable. And Your Excellencies, the International Tribunal for the Law of the Sea, specifically in the Mox plant case, it clearly provides that Article 206 of the United Nations Convention on the Law of the Sea, as well as Article 14 of the Convention on Biological Diversity, does not put an obligation upon a state, but gives a state the discretion of conducting an environmental impact assessment. Therefore, Your Excellency, the argument that the learned agent of the applicant averred that there is an obligation to conduct an environmental impact assessment was just but a mislead to this honorable court, because there is no obligation, but the provisions gives a discretion upon a state to conduct an environmental impact assessment. Secondly, Your Excellency, the question that the applicant did not address before this honorable court in regards to the environmental impact assessment is whether the activity that the respondent state conducted is an activity that requires an environmental impact assessment. And Your Excellency, pursuant to paragraph 11 of the fact sheet, it is clear that the respondent state conducted a marine seismic survey. And Your Excellency, to determine whether or not a marine seismic survey is an activity that requires an environmental impact assessment, Your Excellency, the respondent would like to borrow from one of the most outstanding conventions in matters to do with environmental impact assessment, specifically the Convention on Environmental Impact Assessment in transboundary context, which we shall herein after Your Excellency refer to it as the ESPO Convention. Now, Your Excellency, the ESPO Convention, specifically under Article 2, it provides that states shall conduct an environmental impact assessment when a plant activity is indicated under Appendix 1 of that convention, and it is an activity that is likely to cause adverse effect on the environment. Your Excellency, if we are to look at the first criteria that Article 2 of the ESPO Convention provides as to whether the marine seismic survey is an activity listed under Appendix 1 of the ESPO Convention, Your Excellency, marine seismic survey is not one of the activities mentioned under Appendix 1 of the ESPO Convention, and to that effect, Your Excellency, we can humbly submit that marine seismic survey is not one of the activities that require an environmental impact assessment. However, Your Excellency, we understand that learned agent of the applicant might come before this honorable court and rebut that accusation, basing that there is an activity under Appendix 1 listed as offshore hydrocarbon production, and they might argue that offshore hydrocarbon production is an activity that is inclusive of marine seismic survey. However, Your Excellency, the second amendment to Appendix 1 of the ESPO Convention clearly defines what offshore hydrocarbon production is. And it provides that offshore hydrocarbon production is the extraction of oil and gas for commercial purposes of 500 metric tons of petroleum and 500,000 metric tons of gas. And Your Excellencies, any activity that does not have even a single drop of extraction of oil and gas, that activity do not fall within the realm of offshore hydrocarbon production. Now, Your Excellencies, to determine whether or not marine seismic survey is an activity that has even a single drop of extraction of oil, it is crucial to understand what exactly a marine seismic survey is. And Your Excellencies, learned agent of the applicant did not address or clearly explain to this honorable court what a marine seismic survey is for it to amount to an activity that requires an environmental impact assessment. Now, Your Excellencies, a marine seismic survey is an activity that is conducted on water. And specifically, Your Excellencies, there is a vessel, which is not any kind of a vessel, but a special kind of a vessel that has a back-in. And the purpose of the back-in, Your Excellency, is to lay down a floating cable known as a streamer. And this floating cable has two things. First, it has something called an acoustic source. And secondly, it has certain kind of microphones known as hydrophones. Now, Your Excellencies, the function of the acoustic source is to send compressed air into the ocean, and it passes the sub-layers into the rocks, then it is reflected back to the hydrophones, where the hydrophones collect the data of the subsurface below the water body. Then, Your Excellency, that data is taken to a supercomputer so that it can be processed and filtered so as to remove any other sound, maybe, Your Excellencies, from the vessel that was conducting the marine seismic survey. And at that juncture, Your Excellencies, that data is converted into a 3D format where any geoscientist can read that data and determine whether or not that area has petroleum traps. Now, Your Excellencies, it is crucial to note that marine seismic survey is an activity that only determines whether or not an area has petroleum traps, and Your Excellencies, there is not even a single drop of extraction of petroleum, therefore it cannot fall within the realm of offshore hydrocarbon production under Appendix 1 of the ESPO Convention. And to that effect, Your Excellency, marine seismic survey is not an activity that requires an environmental impact assessment. Your Excellencies, moving on to the second issue in regards to transboundary harm, whether marine seismic survey is an activity that would cause transboundary harm. Your Excellency, first and foremost, it is crucial to note that learned agent of the applicant addressed this honorable court that marine seismic survey, as well as the oil spillage that happened in the Sedna Sea, was the reason behind the death of the Hawksby turtles. And Your Excellency, first and foremost, learned agent of the applicant established the no harm principle, that states have an obligation to make sure that its activity do not cause harm to the territory of another state. And they relied on the Trail Smelter case of 1941, specifically between the United States versus Canada. However, Your Excellencies, what learned agent of the applicant did not address and tell this honorable court that in the same case of Trail Smelter between United States versus Canada, this honorable court went ahead and said only when a state has established that another state has caused transboundary harm, then at that juncture, that state can be held liable for that transboundary harm. And secondly, Your Excellencies, Judge Sue Hanquin, who is one of the learned judge of this honorable court, specifically in her article, Transboundary Damage in International Law of 2003, he goes ahead and says that there must be a direct causal link between the damage that was caused and the activity that was conducted in the area that is said to have caused the damage. And Your Excellencies, What learned agent of the applicants have not been able to establish before this honorable court is the direct link between the death of the Hawksby turtles to the marine seismic survey or to the oil spillage that happened in the Sedna Sea. Your Excellency, the Reefers Institute of the applicant state went on to do a research to determine the death of those Hawksby turtles. However, that research was inconclusive. And to that effect, Your Excellencies, there is no link between the death of the Hawksby turtle to the applicant, to the activity conducted by the respondent state. Your Excellencies, even the diplomatic note under paragraph 13 that the applicant sent to the respondent state, it clearly states, Your Excellency, specifically under line 4, that they are taking into consideration that the actions by the respondent states may have contributed to the death of the 9 Hawksby turtles. They are using the word may have. Your Excellencies, even the applicants themselves, through the diplomatic note sent to the respondent state, they are not sure whether or not the activities conducted by the respondent state are the ones that caused the death of the Hawksby turtles. Your Excellencies, in 2009, there was a workshop of the ISC Regional Hawksby Turtles Workshop held in Puerto Morales, Mexico. And specifically in this workshop, they came up with a report of the most highest threats to the Hawksby turtles population. And specifically, they said the lack of community collaboration incentives for conservation and the change of open ocean conditions, such as temperature, are the most ranked highest threats to the Hawksby turtles population. Your Excellencies, any of these highest threats could have been the cause of the death of the Hawksby turtles and not the activities conducted by the respondent states. Because even the research institute that the applicant state had put specifically on matters to do with the Hawksby turtles could not come with a conclusive evidence that the death of the Hawksby turtles was caused by the respondent states. Furthermore, Your Excellencies, learned agent of the applicant argued before this honorable court that the respondent state should pay compensation for the damage caused. Your Excellency, if I'm to rely on the International Law Commission's articles on state responsibility, specifically under Article 34, it provides that a state shall pay full reparation for the damage caused when a state has been said to have caused the damage to another state. Your Excellencies, in these provisions, it is clear that only at a time when a state has been able to establish that another state has caused damage, that is when a state will be required to make full reparation. Your Excellencies, learned agent of the applicants have not been able to substantiate before this honorable court that the respondent state are the ones who went ahead and caused damage. Therefore, I'm asking this honorable court and even the learned agent of the applicant, to what extent do they want the respondent state to pay for compensation when they have not been able to substantiate that the respondent state is the one that caused damage? Your Excellencies, even if we are to assume that they have been able to establish that the respondent state is the one that caused damage, Your Excellencies, learned agent of the applicant are not telling this honorable court how much compensation should the respondent state pay to the applicant states. Furthermore, Your Excellency, learned agent of the applicant argued that this honorable court should order that the activities that are conducted by the respondent states, they should be halted. Your Excellencies, it is crucial to note that the International Law Commission's articles on state responsibility, specifically under Article 30 to 31, as well as Article 35 to 37, they provide where a state has gone ahead and caused transboundary harm to the applicant state, and it has been established, so 3 conditions arise. First, three obligations arise, sorry, Your Excellency. The first obligation is that the activity should be discontinued. The second obligation is that there must be a guarantee of non-repetition. And lastly, Your Excellency, there is an obligation for a state to make full reparation for the damage caused. Now, Your Excellency, the obligation to discontinue an activity only relies where that activity has been proved to be the activity that caused the damage to the territory of another state. And Your Excellencies, the onus is on the applicant state to prove before this honorable court that the respondent state went ahead and caused transboundary harm. However, Your Excellencies, the applicant have failed to show the burden before this honorable court that the respondent state really did cause transboundary harm. And to that effect, Your Excellencies, we humbly pray before this honorable court that this honorable court should not order the respondent state to go ahead and halt the activity that it has been conducting within its jurisdiction for the purpose of oil and gas extraction. Further, Your Excellencies, learned agent of the applicant went ahead and argued that by virtue of paragraph 2, that they depend mostly on ecotourism, and the death of the Hawksbill turtles affects them, specifically their marine protected area. However, what they did not tell this honorable court is that the same paragraph 2 talks about that the respondent state also depends heavily on tourism and turtle sea watching. Your Excellencies, the Sedna Sea is shared among the three states, the state of Sokovia, Himia, and Nabotia. And Your Excellencies, the Hawksbill turtles are known in that area. And to that extent, Your Excellencies, no state can claim that the Hawksbill turtles are their property, specifically being categorized as migratory species. And to that effect, Your Excellencies, even the applicant state is a state that heavily depends on the Hawksbill turtles. And Your Excellencies, that's why under paragraph 11 of the fact sheet, the respondent state went ahead and put measures in order to make sure that the Hawksbill turtles population is not affected. Your Excellencies, the respondent state went on and put a turtle spotters and ramping up process. Your Excellencies, the ramping up process was a process that, as per paragraph 11, it was meant to make sure that the Hawksbill turtles leave the area and do not come close to that area, so as to make sure that they are not affected. To that extent, Your Excellencies, the applicant state cannot humbly submit before this honorable court that the respondent state is the one that caused damage to the territory of the applicant state, as well as to the death of the Hawksbill turtles population. Your Excellencies, lastly, I would like to submit on the question that the activities conducted in this case, they were activities only conducted by the respondent state, and the state of Nabotia should not be joined. Your Excellencies, as my learned colleague, Ms. Chitindi Marvelous, has been able to establish before this honorable court what exactly a unitization agreement is. Your Excellencies, in matters to do with oil and gas, there is two different things. First, there is a unitization agreement, and then there is a joint development agreement. What learned agent of the applicant submits before this honorable court is a question of a joint development agreement. Your Excellencies, the difference between the two agreements, a unitization agreement, it is between states that have a shared resource, and any of the states can go ahead and do the extraction. However, the two states will share the profits and the loss of that extraction. However, in a joint development, both the two states must conduct the activity together, taking into consideration that there was a shared resource, there was a shared continental shelf. And Your Excellencies, it is important to note that under Article 55, as well as Article 76, both the continental shelf and the exclusive economic zone are calculated by taking into consideration the 200 nautical miles from the baseline. And Your Excellency, we understand that the continental shelf can extend beyond 200 nautical miles, but not more than 350 nautical miles. And Your Excellencies, taking into consideration paragraph 2 of the facts, it is clear that the exclusive... Your Excellencies, I'm asking for 1 minute to conclude.
You may have 1 minute.
Much obliged, Your Excellency. Your Excellencies, taking into consideration that the exclusive economic zone of the respondent state, of the state of Nabotia, is bordering the marine protected area of the state of Himia. And Your Excellencies, that marine protected area is half of the respondent state exclusive economic zone, telling you that the exclusive economic zone of Nabotia and exclusive economic zone of the respondent state are at a different place, calculated with 200 nautical miles from their baseline. However, they are saying that the continental shelf is shared between the two states. a clear indication that the shared continental shelf has been calculated to extend beyond 200 nautical miles. To that extent, Your Excellencies, the continental shelf of the state of Nabotia has extended beyond 200 nautical miles into the exclusive economic zone of the respondent states, and to that juncture they have a shared continental shelf. However, the same place where the shared continental shelf is the same place where the exclusive economic zone of the respondent state is calculated with the 200 nautical miles. And to that effect, the activities conducted in the exclusive economic zone are at the same place where the shared continental shelf is, and therefore the unitization agreement will apply to both the two states because it was in regards to the shared continental shelf. Your Excellencies, if there are no further questions, I'm thankful, and we as the respondent are resting our case.
Thank you very much. There are no questions. So this brings us to an end. Thank you very much.
Your Excellencies, if I may.
Guide you a little bit so we don't take too much time. Could you please just kindly respond to issues of discretion with regards to the EIA, the impact assessment, the seismic survey? I think those were the most important issues. Transboundary harm, you gave us the Canadian case, you gave us a different version. Link, I think there's the oil spillage and the death of the turtles. You couldn't really establish whether or not it was caused by them. So, which was inconclusive. The issue of compensation, how much are you asking for? He didn't tell us. And then lastly, the issue of activities, whether or not they ought to hold the activities. Give us reasons, cogent reasons for that. Thank you.
Thank you, Your Excellencies. I was rising on my feet to exactly, and you read my mind, rightly so. Your Excellencies, if I may first tackle this court, the hue of this court, Your Excellency. Hawksbill turtles don't own passports. They swim free back and forth into the state of the respondent, into the water of the respondent, and equally back to the applicant state. Your Excellencies, in our opening statement, we asked this court, why should we set on a path of self-destruction? We equally noted, Your Excellencies, that the parties before you today have an economic backbone resting on ecotourism. We noted that. And it is not right for the agent the other side to state that you did not take cognizance of that bit. We did. But then, let me answer to the questions raised by this very bench. Mr. President and Your Excellencies, the question on environmental impact assessment. It is a settled position in law now. Your brother judges and sisters sitting in the Park Mills case, Your Excellencies. We are also alive to Article 59, to the fact that it is the decisions of this court are only binding to the parties before it. But it is persuasive, and for judicial consistencies, we will be praying that this court adopts that position. In the Park Mills case, Your Excellencies, it was stated that an environmental impact assessment must be conducted particularly in potential transboundary harm. If potential transboundary harm is likely to occur, and if there is a shared resource. Your Excellencies, is there a shared resource? The Sydney Sea is a shared resource. And to that end, there was need to conduct environmental impact assessment. Your Excellencies, I've loved the respondent agent explaining to this court that we did conduct a seismic survey. What is the purpose of a seismic survey? To find out if there is an oil deposit. That is the essence. They state that they put up turtle spotters. Very okay. They equally say that they increased the ramping up of sound. Perfect. But the question is, was it sufficient? Having the fact that the drilling was only 3 kilometers away, was there an obligation that was heightened? Yes. That obligation was one to ensure that their acts does not cause transboundary harm. Was there anything in the minds of the respondent to make them believe that there might be harm? Yes, and that is why they had the turtle spotters. And that is why they had the ramping of sounds. But nevertheless, even with that fear, Your Excellencies, they went ahead to contract an inexperienced corporation. What was the result? A catastrophic oil spillage. Your Excellencies, we do not argue about the systemic survey. The issue is on the oil spillage that has caused a diverse effect to the environment. Your Excellency, the question next is on the issue of whether there is a causal link. Your Excellency, there is a causal link. The respondent stated what are the likely threats to the hawksbill turtles. But they failed to mention one thing. That one thing is pollution.